Imagine a situation where a beloved family member, perhaps an aging parent or a sibling with a serious illness, can no longer make sound choices about their own medical care. It is a heartbreaking reality many families face, prompting the need for someone else to step in. So, what medical decisions can an appointed guardian truly make to protect their loved one? An appointed guardian can make a wide array of medical decisions for their ward, which is the person under their care. This authority typically encompasses everything from routine health care to significant medical procedures, and even end-of-life choices. The exact scope of these powers is carefully defined and granted by a court, ensuring the guardian acts within legal boundaries and always in the ward's best interest. The fundamental reason a guardian is granted such significant medical authority stems from a legal determination that the ward lacks the mental capacity to make informed healthcare decisions for themselves. This is not a light decision. A court thoroughly evaluates evidence to confirm this lack of capacity. Once appointed, the guardian essentially steps into the ward's shoes for medical matters. This includes approving or refusing medical treatments, consenting to surgical procedures, managing medication regimens, selecting healthcare providers and facilities, and even making complex choices about life-sustaining treatment. The court order specifies these powers, and the guardian is legally bound to follow them while always upholding the ward's well-being as the primary concern. For guardians navigating this responsibility, the practical steps involve careful diligence and clear communication. First, it is crucial to thoroughly review all medical records and understand the ward's current health status. Engage actively with doctors and other healthcare professionals to understand diagnoses, treatment options, and potential outcomes. Do not hesitate to ask clarifying questions, seek second opinions when necessary, and ensure all decisions align with the court order. Maintaining open communication with other family members, while keeping the ward's privacy in mind, can also help foster a supportive environment for decision-making. Guardianship also introduces important legal concepts that shape medical decisions. Two key principles are substituted judgment and best interest. If the ward expressed wishes for their medical care before losing capacity, such as through a living will or verbal statements, the guardian should try to exercise substituted judgment by honoring those known wishes. However, if the ward's past wishes are unknown, the guardian must act according to the best interest standard, making decisions that a reasonable person would conclude promote the ward's overall well-being. The court's guardianship order is the definitive document outlining these expectations, specifying the limits and extent of authority granted. Ultimately, the role of an appointed guardian in medical decision-making is profound, serving as a vital advocate for a vulnerable individual. By understanding the court's authority, actively engaging with healthcare teams, and prioritizing the ward's best interests or known wishes, guardians ensure that their loved one receives appropriate and compassionate care. This meticulous approach provides essential peace of mind for families, knowing that medical choices are being made responsibly and with dignity.